Good morning to all of you. Welcome to Legal Matters by Sai Babu Sunkara. In this video, we are going to discuss regarding the suppression of information relating to the antecedents even by a judicial officer will not be accepted. The judicial officer has been terminated. While dealing with Section 24 of the Advocates Act 1961, already I told you regarding the enrollment process. During the enrollment process, you have to give all information in a clear and legible way. Crypt, clear and legible way. So that is regarding antecedents also. If any case is pending against you, you have to inform the same. Even though you are acquitted in any case, you have to inform the same. Even though the case ended in conviction against you, even though it is not relating to the moral turpitude or SC/ST or untouchability or dismissal, but you have to inform. Why? What is the purpose of antecedents? To know your previous activities. That's all. May be good, may be bad, may be criminal, may not be criminal. You might have been involved also. Some people, as a counter case, they might have involved you. Same thing happened to this lady judicial officer. Now please remember, Supreme Court did not hear the petition of the so-called lady judge who wrote that there were no criminal cases pending against her. But at the time of filing the application, at the time of her admission to judiciary, a case was pending against her. Of course, a counter case is also there. Not only case, due to the village feud, definitely such cases do come. You have to inform. If you don't inform, this is the problem. Now we'll go to the facts of the case. Justice M.R. Shah and C.T. Ravi Kumar recently upheld the termination of the services of a judicial officer who suppressed pendency of criminal case at the time of application. So ఆవిడ అడ్మిషన్ టైంలో అంటే అప్లికేషన్ పెట్టే టైంలో ఆవిడ మీద ఒక కేసు ఉన్నది. ఆ కేసు గురించి రాయలేదు. దట్ మీన్స్ షీ హాస్ సప్రెస్డ్ ద ఇన్ఫర్మేషన్. డెఫినెట్లీ ఇట్ ఇస్ ఎ వెరీ సీరియస్ ఇష్యూ. ఇస్ ఇట్ నాట్? I don't want to name or I don't want to cite the case law because it's not good. జడ్జీలు ఎప్పుడైనా రేపొద్దున మళ్ళీ వాళ్ళు వస్తారు, మీకు మాకు ఇబ్బంది అవుతుంది కాబట్టి కేసు లా లేకుండా ఫ్యాక్ట్స్ వరకే చేసుకుందాం. సో ద లేడీ జ్యుడిషియల్ ఆఫీసర్, రైట్, her name has been figuring as an accused in FIR. Of course, she was the complainant in the counter case also. She has given a complaint, so as a counterblast, her name was also read in the list of accused in FIR. But at the time of application, she said she filled up no as an answer to the query that whether any cases are pending against her. So this is the thing. No doubt, after she got the appointment order, when she got the appointment order, by that time the case against her ended in acquittal because they might have a compromise. I don't know, but the case has gone. So she joined the service with clean hands, but she has not reported the pending of the case at the time of application. This is the major problem. Her appointment was cancelled by full bench, even full bench of the Allahabad High Court also. So they have confirmed her termination. So ultimately, as a last resort, she filed an SLP before the Honorable Supreme Court of India. She said that, no doubt, her name was pending, but her name was a FIR, but the police sent the closure report by the time itself. Police sent the closure report, but the RCS number, referred charge sheet number, was not obtained. Till the referred number, RCS number is given by the court, it is deemed to be pending. But she was of opinion that since the police, they said they have closed the matter, she thought that there is no case and therefore she said no, it's not correct. So the Supreme Court clearly stated that she made a dishonest statement. No doubt, subsequent closure may be there, but it is irrelevant. She has to maintain the facts. Why? The post of judicial officer is a very important, very coveted post in the judiciary. It was expected that the officer should disclose the true and correct facts and they should exhibit the highest standards of ethics. This is what I told you in Rohini Sindhuri versus Rupa Mudgal case also. As judicial officer, as the so-called All India Service Officer, they have to maintain highest integrity, highest ethics. But it was not expected that she has to hide the information. So please remember, right, So another point raised by the so-called judge is that no inquiry was conducted as per Article 311 of the Constitution of India, that is summary dismissal, Article 311. But Supreme Court said, here this is not a case of misconduct, this is a case of concealing information, this is a case of misstatement. So Article 311 does not in any way come into the aspect. So no question of holding departmental inquiry, she is terminated, that's all. So please remember, as a judicial officer, you should be very careful. As an advocate also, you should be very careful. I have given the example of that Addanki Nurse also. You have to go to the enrollment process with clean hands. No doubt, there may be some cases pending against you. You have to disclose the same. Suppose subsequently the case is acquitted. If you inform the same, they will be happy. What for all these things? To know your previous activities, which I told in the beginning of this video. So please do not make any false disclosure regarding your antecedents. With this, I am concluding. Thank you very much.